So there's some interesting news right now regarding prediction markets. So Nevada regulators filed suit against Polymarket, and Massachusetts filed against Kalshi in state court. Up till now, most of the litigation has been fought out in federal courts, and the reason for that is that the state gaming regulators have issued cease and desist notices to Kalshi, and then Kalshi turned around and filed suit against them in federal court, forcing the fight to be played out in federal court, not state court. And it looks like they've learned their lesson, because now, instead of sending a cease and desist letter and having somebody file in federal court, Nevada filed in state court against Polymarket without giving them a cease and desist notice. And Massachusetts recently filed against Kalshi in state court. So it is possible to get something removed from state court to federal court, but that's an extra step and you're fighting on their terms. So it's better for the state regulators to start in state court. And in most of the federal litigation, Kalshi was able to get injunctions while the state case played out. And the only one that has gone to trial so far is Nevada, and that one actually went against Kalshi, and that's being appealed to the Ninth Circuit. So it'll be an important case. But in order for you to get that injunction to be able to keep doing business while the case plays out, you need to show two things generally. One is irreparable harm, and two, likelihood of winning on the merits. And given that the only case to decide this now in Nevada went against Kalshi, the other prong of that, the likelihood of success on the merits, is sort of against them. And in Massachusetts, the judge issued an order which would allow for a injunction, and there's going to be a hearing to decide exactly how that's going to play out. Does that mean no new sports bets with Massachusetts residents? Does that mean that existing bets are still on and you have to wait for them to be over? Does that mean that they'll have to cancel these existing bets? That's still on the table. But this initial round went against Kalshi. So Kalshi brought up the issue of preemption again. And just a reminder, some areas of law are preempted by federal authority. There's no state authority. So in things like national defense and other areas of the law, they sort of coexist. So for instance, the SEC regulates securities, and each state has their own securities regulator. So securities law is not preempted by federal regulation, but generally trading in derivatives on exchanges is considered to be preempted. And the preemption applies not only to the states, but to other federal regulators. So there's a case called the IPS case dealing with index participations. And because the CFTC statute says that they have exclusive jurisdiction over commodity interests, which are traded as futures, then if something is a securities and a derivatives contract and it's traded on an exchange, the CFTC has exclusive jurisdiction. And that case involved index participations for which the long side looked like a securities and the short side looked like a futures contract. And the court said that if any part of that is a futures contract, the CFTC has exclusive jurisdiction. However, the state judge did not find that preemption exists with regard to sports wagering, because that is an area that's traditionally reserved to the states. And although it's not explicitly stated here, there is a canon of statutory construction that's very memorable. It's called Congress Doesn't Hide Elephants in Mouse Holes. And a month or two ago, the 10th Circuit issued a ruling in the case dealing with Custodia Bank, where part of an amendment to the statute contained the word shall, and the banks had argued that now the Fed has to give them access. They don't have any discretion. And the court said Congress doesn't hide elephants in mouse holes. If they intended to change the way that banking has worked for the past 150 years, they wouldn't do this in a technical amendment to a part of the statute that deals with schedules. They would make it more obvious. And that's sort of what the preemption theory is here, because if Congress had intended to take away the regulation of gambling, which for the entire history of the United States has been a state issue and give that to this obscure federal agency, that would be part of the federal record. It would be obvious in the statute. It wouldn't be something that you have to connect the dots to do. And so, although that's not explicitly stated here, that canon of statutory construction, that's sort of what undergirds it. And people learn from their mistakes. And since Kalshi has had success in the federal courts, except for Nevada, they're learning from that. And rather than giving them cease and desist notices, they're just directly filing in state court, as Nevada did against Polymarket and as Massachusetts is doing against Kalshi. And other states may take the same track now and try to fight this out in state court. So states have traditionally had jurisdiction over gambling and sports betting. So just because you craft this so that it is a futures contract, does that mean that the CFTC is intended to have exclusive jurisdiction? And that's an interesting question, and it's more of a legal question than a philosophical question. But if you look at the definition of commodity, it's pretty broad, but it's questionable whether any of this includes the outcome of a sports event. So swaps and futures are instruments where the underlying is a commodity, and if you're trading something where the underlying is not a commodity, would the CFTC have exclusive jurisdiction over that? Or would they have any authority to approve it at all? And when the first event contract was approved, that was one of the things that was raised by the dissent. So this is the dissent of Commissioner Summers. And an exchange offered to list weekend motion picture receipt futures and binary option contracts on those. And although it was approved by the CFTC back in 2010, the dissent by her makes the point that I just made, which is that if you look at the definition of commodities, it is pretty broad, but it is unclear whether that would be broad enough to encompass motion picture revenue receipts. And so if that's the case, we shouldn't be approving contracts on them because it's not something that we have jurisdiction over. And if that was a stretch, then whether the Giants win against the Cowboys, that's even a bigger stretch. And that is one of the issues that's being litigated in court, is whether these are actually the proper underlying for a swap for which the CFTC has exclusive jurisdiction when they're traded on a designated contract market. So if you look at the CFTC's grant of jurisdiction, it actually uses the word exclusive jurisdiction. So it contemplates no one else, not the SEC, not the states. No one has jurisdiction besides the CFTC when it comes to trading derivatives on an exchange, and the underlying of the derivative is a commodity. So if the underlying is a security, the SEC has jurisdiction, and if the underlying is what's called a mixed swap, they both have jurisdiction. But with regard to commodities on an exchange, whether that's traded as a swap or a futures contract, the CFTC has exclusive jurisdiction. But again, that's on commodities. And is the outcome of a sports wager a commodity? And if not, then the argument is that the CFTC either doesn't have the authority to approve them, or at the very least, they don't have preemption with regard to that. So that's the issue being litigated in state court. Let me know what you guys think about this. And if you'd like to consult with me on a professional basis, use my contact information in the bio. Have a great day, everyone.